Uh, Thank you, all of you, for joining us. Today's webinar is organized as the sideline event of the 48th session of Human Rights Council by Kashmir Institute of International Relations in collaboration with World Muslim Congress. The title for today's seminar is Criminalization of Peaceful Expression. The webinar is intended to debate on the draconian laws that are used by state parties to restrict and criminalize the right of peaceful expression and opinion. We will be studying the case of Indian laws and in practice that criminalize peaceful expression are inconsistent with its international obligations. The government has time and again used draconian laws such as sedition and criminal defamation laws to silence the peaceful resistance of people of Jammu and Kashmir for the realization of the right self-determination. These laws are vaguely worded and poorly worded and have been used as political tool against the critics, showing a movement towards thought crimes. The recent amendments in certain laws have made them even more perilous and violate the mandate of Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, and puts fundamental rights of citizens in peril and threatens the mere existence of opposition. Under the guise of such laws, the government has booked several political leaders, journalists, human rights defenders who are doing their job, and citizens fighting for their rights. Today I am being joined by a very learned panel. I have with me former Senator Lee Rehanen from Australia. Last Rai, former MP from Norway. He will join us at 5:30 time. We have with us Alfred Marcus Diaz, former UN independent expert on the promotion of a democratic and equitable international order. We have with us also Advocate Nasir Qadri, who is a human rights activist from Indian occupied Jammu and Kashmir and is a doctorate fellow at Law of Armed Conflict. We have been joined by Advocate G.N. Shahi. He is a spokesperson of High Court Bar Association. Mariana Zaka, she's a good friend of ours. She's from Italy, a human rights expert, and is working currently with the Interior Ministry of Italy. Professor Shogufta Ashraf, who is coordinating this webinar, and sadly, Ms. Naima Mahjoor will not be joining us because of her health issues. So, ladies and gentlemen, let me start with Advocate Nasir Qadri, as he has been practicing law in Srinagar and has been dealing with the cases of the victims of the Indian oppression in occupied Jammu and Kashmir. Nasir Qadri, sir, you have the floor.
Okay, Assalamu alaikum, good afternoon, good evening, distinguished panelists. Thank you, WMC and KIR, especially Mr. Wani sir, for organizing and inviting me in this virtual debate on the sidelines of 48th session on UNHCR. This is a timely debate on the criminalization of this freedom of expression, where entire India has been saffronized by the ultra-nationalist BJP, Hindu BJP, and its militia group RSS. And then everyone knows the Indian occupied Kashmir have been a laboratory laboratory to test all these horrendous acts and legislations. Coming to the Kashmir and the application of these or invocation of these laws, Kashmir, as we know, Kashmiris are fighting the war of liberation for the self-determination from last 73 years. And it is not the first time that the freedom of speech and expression has been curtailed. I mean, to put it correctly, India as an occupying state has a baggage of war crimes, crime against humanity, crime of aggression, or we can say the baggage of blood. India has been using in perpetrating all these war crimes. and to resort or take recourse of the legality of the violence. Now they're bringing either the amendments or the the draconian laws, like Public Safety Act is there, Armed Force Special Powers Act, which has been criticized by the global community, as well as this Enemy Agents Ordinance Act. Even the martial laws, like the Act of Army Act 1950, or Border Security Act, which is called the BSF Act 1968, or there is another Central Reserve Police Force Act 1949, which govern the functioning of the Indian occupying troops while deployed on the so-called counter-insurgent duties. Basically, the war ravaged occupied territory, the Kashmiris, which include the indigenous armed fighters. They're fighting the war of liberation within the ambit of international law, within the ambit of the Geneva Conventions or any other treaties for fighting for the case of these. Coming to these laws, these laws and the Supreme Court judgments, to be particularly the Supreme Court, which rendered under these acts, provide that the military courts can try military courts can try all acts of a military indiscipline and all crimes committed by the court-martial proceedings. These laws within the closed doors, they try these laws and initiate the proceeding at the option of the military authorities. These are the acts. The question of the police power in these acts to register a criminal complaint against any of these armed forces is currently being litigated in the Supreme Court of India, and the police are injected for filing any such complaints as an interim measures. Jurisdiction of the civilian courts in the occupied territory, to put it correctly, over crimes by the military occupying troops or the military personnel is further proscribed through the legal impunity or immunity called the provision of the extraordinary laws, such I have mentioned the Armed Force Special Powers Act, which has been criticized by the two reports as well. Office of the High Commission for the Human Rights, two reports in 2018 and 2019. They say that the excessive use of power is all because of these Armed Force Special Powers Act. It has jeopardized every legal system out there in the occupied territory. Unlike the Palestinian occupied territory, the crimes by the both combat and which are being committed there, the situation is akin in the occupied territory of Kashmir and the Palestinian occupied territory. These anti-terror laws, be it Unlawful Prevention Act, UAPA, Public Safety Act, or any other these anti-terror laws, these legislations develop the concept of hyper-legality. We have to understand this. This is one of the author I was reading. There is a study, proper study. These anti-terror legislations develop the concept of the hyper-legality to describe the structure and the permanent shift from the liberal mode of governance in which the emergency is conceived and the withdrawal of the law and the institution of the temporary rule by the executive power without a judicial or legislative check, which is important. There is no check without the judicial or legislative check in the response to a special crisis, to a distinctive mode of governance that is triggered by inchoate determination of the danger and draws upon the racial legacies and generalized anxieties as the British, these colonial government used to do. This hyper-legality is characterized not by this, the suspension of the law, but rather by the development of the complex and multiple bodies of the legal authorities, like the special tribunals, so-called, the special authorities, the special venues, and the bureaucratic classification, involving a predictive quality based on the profiling. Individual on the basis of who they are. See the act, if we go, if we analyze this UAPA particularly, its sections, particularly the amendment, the recent amendment in 2019, anybody can be a terrorist in the Modi's government. So this hyper-legality, in this sense, it is who they are and what likely to do. So in Kashmir, the system of the criminal justice and the preventive detention in the occupied territory operates not a separate system, but contingently and concurrently, such that the multiple and the repeated police complaints and criminal cases. One, there is an administrative arbitrary detention, and it runs concurrently with the criminal justice, so-called the adjective laws. I'll try to explain and sum up because we have a very less time. The police or the criminal on the basis of the police dossiers, so-called dossiers, and the executive detention orders, which simultaneously disrupts and delays the criminal trial, and the inevitable result in the acquittal due to lack of the evidence. I'll just give you the example. One of the case is pro-freedom activist, now a chairman of all parties Hurriyat conference, Musarrat Alam Bhatt. He is facing 38th detention now. He has been, booked under the substantive offense of this so-called UAPA, anti-terror law. One of his police dossier, this Public Safety Act, it is basically the detaining authority tells that I am detaining someone on my subjective satisfaction. Let me tell you what was his subjective detention in one of the, dossier. The detaining authority is writing that since you are born as anti-national, hence, it becomes an imperative to book you under the Public Safety Act. See how insane the India is, how insane the detaining authority is. How can a person be an anti-national from his birth? Even Americans couldn't use the term to the Osama bin Laden that you are by birth an anti-American. This is how India operates. This is how legality operates in the so-called this India. And then I have a very senior and my dear, senior colleague with me. I have met him, Jian Shaheen, a learned counsel, a learned advocate. He was also detained in 2010. I know I was there practicing with him. A general secretary. You know why he was detained? Why a dossier against our learned panelist? It's all because he was defending the human rights. He was defending the UDHR. He was defending the law. So see how mechanical these detention orders are being drafted. You are, to keep you out seems a threat or the public order threat or the security threat. Hence, it becomes imperative to book General Secretary of Bar Association under this so-called draconian law. So this is the how situation, the occupied territories vis-a-vis these draconian black laws. I'll give the recent data, which is based on the India's National Crime Bureau record. Kashmir, Kashmir though is not a part of India. Kashmir, now they include the forcefully they say it. The Kashmir occupied territory has the highest number of these cases, because since I told you, I begin my speech with that Kashmir occupied territory is a laboratory for all these laws to test, because they don't consider Kashmiris the humans. The hardest place in the planet is the occupied territory for the living without the basic human rights. The National Crime Bureau record, 1,948 people were arrested under this Unlawful Prevention Act, UAPA, in 2019, and the increase of nearly 37% from the previous years. There's an increase now in the Modi's India, and then now with with the baggage of blood. Now they're too tired killing Kashmiris. Now they want the legality of a violence, like to justify the legality. They bring these laws, and in these cases, the data is only 2.2 criminal cases registered under this UAPA from 2016 to 2019 ended in the conviction. Only 2.2 cases, and nearly 11% cases under this the draconian law were closed by the police for the lack of evidence. There's no evidence. There are so many dozens of cases. Due to the paucity of time, I cannot, explain. But there are dozens of cases in which, after 15 years, a person was acquitted of no charges under this the UAPA. Even, talking of the media, which is important. Now the state is using a tool. I'll come to the topic, and this is I'll conclude with this: the absolute, the criminal is how they are criminalizing the dissent. The journalist is working in the occupied territory. Since 2019, there has been numerous, communications from the special reporters, the different, multiple statements from RSF and other international journalist bodies condemning the action of these occupying authorities or establishment vis-a-vis the journalism concerned, because there is this absolute censorship post 2019 when India abrogated the semi-autonomous structure. Even if I don't know how this is only the state in India. Even the Afghanistan, the situation is different. Kashmiris are fighting a war of liberation. There isn't if you categorize this conflict, it comes under the ambit of international armed conflict. For the sake of argument, the indigenous armed rebels are operating there. Even if it is a non-international armed conflict under the IHL, even then the media, if used under propaganda, cannot be deemed as a military object. This is the rule of the IHL. Even if a media operating as a propaganda, it cannot be deemed as a military object. The illegality of attack on the journalists, news media derives from the protection granted to civilians and civilian objects under international humanitarian law. So both journalists and their equipments benefited from the general protection enjoyed by the civilians and civilian objects unless they participate in the military action. So there is an absolute cover under the international humanitarian law. And even India is party to Geneva Convention. India has their own domestic legislation as Geneva Convention Act of 1960. The act obliges India to implement and respect all the humanitarian laws. According to, I'll just refer to the Rule 34 of the Customary International Law, which says that the civilian journalists engaged in the professional mission in any areas of the armed conflict. Since the Kashmir is an international armed conflict, India, Pakistan have fought 3 major wars in the Kashmir. So it is categorized as an international armed conflict. So the journalists there must be respected and protected as long as they do not take a direct part in the hostility. The protection almost the same in the international end as well as the non-international armed conflict. Even if the Kashmir is categorized as a non-international armed conflict, the protection to the journalists remains the same. There are then the resolution, I cannot elaborate. There are the Security Council resolutions, resolution of 29, 1997, the UN Security Council resolutions 178 of 2006, particularly on these journalists, the Medellin Declaration, May 4, 2007, the Declaration of the Safety of the Journalists, 2009. In all those resolutions, the resolution condemns the attack on the journalists in the conflict situation and urges members to investigate all the act of violence. In some sense, if you interpret the act, any act, intimidation, which an occupying army does to the journalists, it is basically a war crime. Yet there are numerous war crimes, they commit one more. I will, to conclude this, I cannot take much of the time. Thank you, Wani Saab, for patiently hearing. So I will conclude with the analysis. This is a very important analysis by Dr. Ghosh vis-a-vis these draconian or the laws are concerned there, the UAPA or the preventive detentions. Dr. Ghosh has conducted a survey and analyzed the everyday legality of the preventive detentions, the regime, preventive detention regime in Kashmir as a means of waging war against political dissent. She sums her study, if I'm allowed to read this, in the arena of counterinsurgency lawfare, spectacularly and terrifying mode of state brutality, secret evidence gathering through the surveillance, police abduction, nocturnal raids, enforced disappearance, custodial torture, and the identification and disfigurement of the children's, making as habitual protesters, using crowd control technologies such as the pellet guns, or reinscribed through modalities of the routine paperwork and courtroom performance. The working of the legal regime based on the suspicion, terror, provisionality, and the secret evidence are rationalized through juridical, documentation in the criminal justice and administrative detention system, such as an open FIR, which is very common, and public safety act orders that intersect and reinforce one another. This mesh of documentation that concatenated chains of the identical words, open FIR, the copy and paste of the aesthetic of the dossier, and the mechanical reproduced public safety act detention orders serve to create a depersonalized yet individualized system that is opaque, to substantive judicial review as whole, though individual cases repeatedly fail to meet the test of constitutional law on the standard grounds of clerical error on the non-application of mind. So these laws are complete, not only the international, the ICCPR, the UDH, or any other laws, their own judicial laws, their own so-called democracy, they call themselves one of the largest, or the written form of the democracy, the laws, it violates, on the face, it violates these the judicial canons. I rest here. Thank you very much. Thank you, Vanessa. Thank you.
Thank you, Advocate Nasir Qadri, for your valuable inputs. You rightly pointed out towards the hyper legality, what you called it, and what are the legal frameworks India has been employing in Indo-occupied Jammu and Kashmir to suppress the people's resistance for their right to self-determination. As we know that this right to freedom of expression is enshrined in Article 19 of the Universal Declaration of Human Rights, which sets out in broad terms the human rights that each of us has. It has been already also protected legally by the raft of international and regional treaties, which, of course, Nasir Qadri was telling us. But freedom of expression also underpins other human rights, such as the right to freedom of thought, conscious religion, and allows them to flourish. But unfortunately, the states, in one way or the other way, they are using these laws, and this is under attack and to strive with criticism. So I will straight away go to Italy, to Mariana Zocca, as she is in office. She has started in the office. She's on job. So Mariana, you have the floor. You have 7 minutes. Mariana.
Thank you so much, Mr. Wani, and let me say thank you for inviting me and wanting me once again in this panel as a side event of the UN Human Rights Council, which was supposed to be one of the biggest platforms to make international politics meet human rights activists and civil society. So we are here today to talk about freedom of expression and all the other rights that you have just mentioned in relation to the laws that are still used in India. As you said, I am a long friend of the Kashmiri Institute, and I have been studying the Kashmiri situation for a long time. And so I would like to start by saying that in 2019, in August 2019, India imposed an unlawful and completely illegal lockdown and siege in the Kashmiri occupied territory. And what was done by the first moment of its occupation was the restriction, a large restriction of freedom of expression, and it also has imposed large restrictions on the work of human rights activists and journalists. And then I would like to remind that we are here to analyze certain laws that are still legal in the penal code of India. First of all, the sedition law, especially section 124A of India Penal Code. And this law is a colonial era law that is still used against dissidents, but also human rights activists and people in general from India or whatever places that are in the territory of India, and they are peacefully protesting against the Indian government. The sedition law prohibits hatred or any kind of contact that excite or attempt to excite disaffection or disaffection against the government or towards the government established by the law in India. However, this law is very discussed also by Indian parties because it has a very large interpretation, and if we go to see the charges that every year policy imposed against people for a sedition law, this is a large number. And there is also another law, the criminal defamation law, that is used to suppress critical speech and harassment. When the Supreme Court of India was asked about the legitimacy of this law and the sedition law, it said that a person's right to freedom of speech has to be balanced with the other person's right to reputation. However, studying the issue of Kashmir and studying what the Indian government has made throughout all those years, those kind of law are not used against only that people that are trying to waste or destroying another person's reputation. Instead, those kind of laws are using against all that people that are freely and peacefully trying to demonstrate and to share their own ideas. Furthermore, they are also used against journalists that are just trying to tell the world what's going in the occupied territory of Kashmir and what Modi's government is doing. However, given that we are here to talk about human rights, I would like to remind you about a fact. In 1979, India has ratified the International Convention on the Civil and Political Rights, which was born by the Universal Declaration of Human Rights. Both of those treaties, the first one, the Universal Declaration, is just a declaration, but the second one, the ICCPR, is a covenant. Both of them embodies the so-called norms erga omnes. It means that they are legally binding for each state. And it means that ratifying powers, ratifying states have to fulfill and respect and grant the laws and the rights embodied in the ICPR to their own citizens. So India government should respect and adapt its own legal standards to the international ones. The ICCPR underlines the fact that the right and the freedom of expression embodies not only the freedom to express our own opinion, but it also recognizes the freedom to seek, receive, and impart information. It means that journalists, human rights activists, and people in general should be free to narrate, to tell, and to say not only whatever they see, but also in respect of each one's dignity, they are free to comment and to public share their own ideas. It was not possible to do that during August 2019, and I do remember the hard work that journalists were meant and supposed to do during the siege in the Kashmir occupied territories. Furthermore, the ICCPR also recognized the right to hold opinions without interferences, and it means that the state, in this case India, should not interfere with the work of these people and the right of Kashmiri and Indian people to come to know what is happening. However, the other point that should be discussed about sedition law, Indian sedition law, is that it provides for a maximum charge, such as it also maximum punishment with life imprisonment. So, for example, during the Kashmiri lockdown, people were peacefully protesting in the streets of Kashmir. Many of them have been punished, and even today they may be punished with life imprisonment, with those very hard kind of punishments. I would also like to remind about the fact that ICCPR also provides for a treaty body, that is that body meant to control states that are. Can you hear me?
Yes.
Oh, okay. I just saw the message of Mr. Wani. However, the treaty body is meant to monitor the implementation of the ICCPR, and the ICCPR treaty body is called Human Rights Committee. The Human Rights Committee has stated out that freedom of expression also is meant to grant free communication, the freedom to share information and to share ideas about public and political issues. So each one here and in whatever state should be free and feel safe to share and to say her or his own opinion, even if it goes against the established government. And I would like to remind that ICCPR has many times through its treaty bodies remind and highlighted the fact that freedom of expression embodies all forms of it. As said by the European Court of Human Rights, and I would like to say this, because I think that it's very important nowadays, in general, worldwide. The freedom of expression is the essential foundation of a democratic society, and it is the condition for progress and development of every man. And I do really believe in this. Furthermore, the UN Human Rights Committee the Human Rights Committee of the ICCPR has also recognized in the name of the ICCPR that the freedom of expression may be restricted only in few cases. For example, in those cases provided by the law. However, the law established in India is used against minorities in a discriminatory way and in order to mute whoever speaks against government's impositions. Then it is also very controversial. Furthermore, the ICCPR also recognized that restriction of freedom of expression may be done in the name of peace. It means that restrictions are allowed in the case of any propaganda for war or advocacy for a national Russia or religious incitement to discrimination, hostility, or violence. This is not always the case of churches for sedition in India. Instead, those people speaking up for Kashmiri situation or Kashmiri occupied population and territories, most of the times are silenced by the government. And I would like to close my speech by saying that freedom of expression is an enabler of other rights. In fact, we cannot think about, nor we cannot define the right of freedom of association or assembly without saying that freedom of expression is not granted in a certain state. Moreover, freedom to take part to cultural life is not possible if freedom of expression is not granted. And furthermore, enjoying benefits from scientific progress is not possible without freedom of expression. But last but not least, I would like also to underline this critical point. Whenever we have a human rights violation or largely and widespread human rights violations, asking for redress, asking for peace is not possible without freedom of expression. So we should ask ourselves and ask to the international community how democratic is a state that is restricting the freedom of expression. Thank you so much for letting me speak, and thank you, Mr. Wani.
Thank you, Marina, for your wonderful input. As you rightly pointed out, India as a state party is violating the ICCPR. And its international human rights obligations under its terms of the treaties. That includes indirect and indirect censorship of Kashmiris, expression of their political subjectivity on social media and in print media or otherwise, and blocking their access to the digital space through extended internet and telecommunication shutdowns since 2008 onwards. So we have been joined by Lars Rice. I welcome Lars Rice, a very good friend of people of Kashmir who has been championing the cause of Kashmir for long. Warm welcome to Lars Rice. But before Lars Rice, I would like to have the recorded statement of Alfred Dizias, who has been the independent expert of the UN Human Rights Council on the promotion and protection of international democratic international order. Alfred has given numerous reports to the Human Rights Council on the self-determination of the people of Jammu and Kashmir. So I will now request Maher to have the video message of Alfred. If it's possible, easily.
Here you go. Excellencies, colleagues, ladies and gentlemen, good day. Lawfare has been used and is being used by India to suppress the legitimate exercise of the right of self-determination by the people of Jammu and Kashmir. This is contrary to international law, in particular to international human rights law, and contravenes the 1948 Security Council Resolution 47, which recognized that both India and Pakistan had agreed to conduct a plebiscite in the region. By virtue of the UN Charter and Articles 1 of the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights, all peoples are rights holders of the right of self-determination, as states are the duty bearers. Therefore, India is bound to allow a plebiscite in the region, and the UN General Assembly should adopt a pertinent resolution reminding India of this obligation. Moreover, an advisory opinion by the International Court of Justice would be useful to clarify any and all legal questions concerning the referendum. For decades, the right of Kashmiris to freedom of expression and peaceful assembly have been systematically violated. Kashmiris are being subjected to arbitrary arrest and detention, contrary to the International Covenant on Civil and Political Rights. India is a state party to the International Covenant and is bound by Articles 19, 21, 25, which guarantee the rights to freedom of expression, the media, public manifestations, and participation in the conduct of public affairs. Although India has not ratified the optional protocol to the ICCPR, which means that individuals cannot submit cases to the Human Rights Committee for examination, the committee can examine the Kashmir situation during its examination of India's periodic report under Article 40 of the Covenant. Other United Nations treaty bodies can also conduct inquiries into the situation in India and Kashmir, including the Committee on the Elimination of Racial Discrimination, the Committee on the Elimination of Discrimination Against Women, the Committee on the Rights of the Child, and the Committee on Economic, Social, and Cultural Rights. India must also submit periodic reports to these committees, reports which are discussed in public. Therefore, human rights NGOs can participate in these events and should inform the expert members of these committees. The Human Rights Council should also be seized of the matter, including through its special procedures, the UN Working Group on Arbitrary Detention, and the rapporteurs on freedom of expression and manifestation. The international community must denounce a scandalous situation prevailing in India today, which turns victims into perpetrators when India defames legitimate national liberation movements as terrorists or rebels, when all that the Kashmiris demand is respect for their national identity and for their religion. The international community is further concerned that the Indian constitution was modified in order to change the status of Kashmir by allowing a demographic manipulation intended to convert Kashmiris into a minority in their own land, a process which has already begun. Jammu and Kashmir are essentially sealed off. Nonetheless, information is smuggled out that most of the prominent political and civil society leaders have been arrested or put under house arrest. There is consternation over the fact that those imprisoned are exposed to other prisoners affected by COVID-19. We note with satisfaction that the United Nations Secretary General has asked the Indian authorities to release the Kashmiri leaders and other political prisoners. We call on the 48th session of the Human Rights Council to continue demanding India to allow the holding of a referendum in Jammu and Kashmir and to grant observer status to the legitimate representatives of Jammu and Kashmir. The Office of the High Commissioner for Human Rights should follow up on its previous reports on the situation in Kashmir and ensure that the human rights of all Kashmiris are respected. The evidence demonstrates that Indian authorities are committing state terrorism in Kashmir. This should be documented and recorded by OHCHR. The mainstream media must disseminate rather than suppress this information. I thank you.
Thank you. This was Alfred Zias, who was recommending that Human Rights Council should continue its monitoring of the situation of Indian occupied Jammu and Kashmir and report to the UN General Assembly and others, and also recommended that the civil society actors should report to the UN committees, UN Human Rights Committee and special rapporteurs. But what we see normally in Indian occupied Jammu and Kashmir, those who coordinate or those who cooperate with the UN systems are facing the harsh reprisals at the hands of the Indian government these days. Recently, we have seen lots of communications by the special rapporteurs to government of India to this end, and to our dismay, the Secretary General's report, which was released on reprisals and intimidation against individuals and groups seeking the cooperation to cooperate with the UN human rights. Once again, this report identifies a very concerning number of threats and attacks aimed at silencing human rights defenders in irritation of their engagement with the UN. And the people of Kashmir and the human rights defenders in Kashmir have been facing this for long, and we have a substantial evidence from the special rapporteurs as well as in the two reports of the OHCHR and also Secretary General's report released recently on the reprisals. Now, I will go to Senator Lee Ryan, direct to Australia. Senator, you have the floor.
Thank you very much to the organisers of the seminar. It's really good to be with everybody. It's been wonderful to the previous speakers. I did just want to say a little technical thing at the beginning. I've had a lot of trouble hearing people. I'm wondering if it's at my end. I usually don't have this problem, but I've just seen a dialogue that there is a weak internet connection. So you do hear me. Okay, good. I'll keep my fingers crossed. So this global event is timely and I believe very significant in light of the dangerous deterioration in respect for and adherence to human rights in India. For a number of years, leaders and associates of the BJP in India have been committing shocking crimes. The world community responsibility for the brazen way Narendra Modi and Home Minister Amit Shah continue to perpetrate these crimes. There is barely a question or a word of criticism from most world leaders. I see this very acutely from Sydney, Australia, where I live and work. The government, like many Western governments, is mounting a new Cold War on China while refusing to speak out against similar problems occurring in India. Australian Prime Minister Scott Morrison regularly attacks China over its aggressive military actions, treatment of its citizens, and lack of democracy. I'm not saying those criticisms should not occur, but let's compare this vitriol, the attitude of many Western countries, to India. The Australian government is expanding its without a word of increasing human rights abuses in that country, the corporate takeover of Jammu and Kashmir, and of the country's legal system to facilitate these dangerous trends. Due to time constraints, I will not explore here why Western powers are taking this soft approach to India. To explain, I spoke about the India-China comparison to give a global context for today's webinar, Criminalization of Peaceful Expressions. That phrase, criminalization of peaceful expression, sums up the actions of the BJP at a federal and state level. We need to remind ourselves why Modi, Shah, Yogi Adityanath, the Chief Minister of Uttar Pradesh, and other BJP leaders have taken an approach that promotes violence and oppression against those who they disagree with. The BJP leaders have taken an approach that promotes violence and oppression to those they disagree with. The BJP is committed to Hindutva, a political ideology that promotes extreme Hindu nationalism. The result is mounting attacks on India's minorities, particularly Muslims. This needs to be exposed. A corrupt legal system enables these crimes to occur in India. Today, a series of laws facilitate and legalise the violent abuse, discrimination, and growing intolerance many minorities suffer. I will run through some examples of the way the BJP are manipulating the judicial system to achieve these ends. Previous speakers have well covered examples of other oppressive laws. These facts together illustrate how India is criminalising peaceful expression. Sedition, a relic law from the days of the British colonial rule over India, remains on the statute books. It is used by the BJP authorities to crush opposition forces. A recent example of how this law is misused occurred in India. 3 students were charged and jailed on charges of sedition and for attempting to disrupt communal harmony. The charges were laid after a video went viral that allegedly depicted the students uttering pro-Pakistan slogans. The charges came about after Hindutva groups complained about the students' actions. In recent times, a huge array of people have been arrested on sedition charges. Political activists, farmers, students, and people supportive of progressive causes. Last year, 4 former Supreme Court judges in India called the repeal of sedition laws, and in particular, the Unlawful Activities Prevention Act. The judges raised concerns that these laws are misused to quash dissent and restrict the activities of those opposing the ruling authorities. Another law that gives cover to many of the shocking crimes committed by the Indian authorities is the Armed Forces Special Powers Act. This legislation, passed in 1958, is also modelled on a British law. It provides the Indian military with immunity from prosecution for civilian killings. Since 1990, a version of this law has operated in Jammu and Kashmir. A recent incident that comes under this law has thrown a light on the level of abuse the Indian Army can engage in with little fear of consequences. When 3 young men from South Kashmir were found dead with weapons on them, Indian military personnel initially attempted to claim that they were killed in a shootout. The army accused the 3 of being militants. But after the men were identified by their families as labourers who had been looking for work, the army had to acknowledge that there was prima facie evidence that its troops had exceeded their powers. Army personnel have stated that there will be disciplinary proceedings taken against those responsible for the killings and planting weapons on the young men after they were killed. While this crime has been exposed, in by far the majority of cases, Indian military personnel using the cover of this notorious legislation get away with shocking crimes, including torture, murder, arbitrary detention, and enforced disappearances. There are a raft of other laws and policies in India that add up to a punitive culture that enables BJP operatives and supporters to harass progressive activists, journalists, academics, and others who speak up to expose the crimes of the Modi forces. In June last year, a new media policy was adopted for Jammu and Kashmir. The 53 pages, believe it or not, document will effectively kill off media stories. The Indian central government public relations narrative will dominate the news. How it works is that effectively, Kashmiri journalists will be replaced by a bureaucrat or police officer who will have the power to determine what is news and what is not. Then there is the Foreign Contribution Regulation Act. The tough government regulations and oversight in this law will be used to harass outspoken rights groups and cut back on their funding. The Official Secrets Act and the National Security Act are also used to criminalise peaceful activities. The extent of the legal manipulation occurring today in India is phenomenal. Democracy and justice have become just a shell of what the leaders of the anti-colonial movement work for. I acknowledge that great work is being undertaken in India and among the Indian diaspora to restore India inclusive democratic society. To achieve this won't be easy, but good work is being undertaken. The growing #LetKashmir global movement is building. It's working to play a key role in obtaining the right to self-determination for Kashmiri people. There is also a role for the governments of other nations to speak up about human rights abuses occurring across India. We need many voices to speak out with concern about law changes that violate the essence of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights. History shows us the parliamentary leaders find the courage to take on extreme anti-democratic forces like BJP when there is a strong global movement to stand to the fore in this struggle. I believe the key to India rejecting the extremism of the BJP and the RSS forces lies with a loud, principled global public voice for an India that supports self-determination for Jammu and Kashmir, protects human rights, and stands for a fair and just judicial system for all. Thank you very much.
Thank you, Senator Lee. You brought in very important points. You talked about the laws which are being used to criminalize the freedom of expression in India and also in Indian-occupied Jammu and Kashmir. You also talked about that now civil society is doing a very good job all around the globe to create awareness about the human rights situation in Kashmir, but it's now turn of the political governments around the globe to speak up like they speak up in other cases. They should take on India and they should make India accountable of its crimes against the humanity and criminalization of the, especially the way they are criminalizing the freedom of expression in Indian-occupied Jammu and Kashmir in India. You also mentioned about that how the hate speech is creating the problems in India is the Article 4 of the International Covenant on the Elimination of All Forms of Racial Discrimination, ICERD. requires the state party to outlaw hate speech and condemn all propaganda and organizations based on racial superiority of one group over the other. As a state party of the ICRD, India is in violation of its commitments under the terms of ICRD because IT cells in the run by the state actors and politicians in India in the digital space routinely engage in Islamophobic propaganda and hate speech, which calls for the genocide of Kashmiri Muslims. What the Indian Army is doing in turn, and respond to the speeches of the BJP and RSS leaders in India. Now I'll bring in our friend. He has a lot of commitment these days. Last rise. Please, you have the floor.
Thank you very much, Mr. Chairman, Your Excellencies, ladies and gentlemen. Thank you for the invitation to take part in this very important webinar. I'm honored to be invited. And I have to say it's a sad topic that we have to discuss today that is now connected to criminal law to express your opinions in Kashmir. When I grew up, we learned that India is the biggest democracy in the world. It has 600 million inhabitants and has a division of power in 3 branches: the judicial, the legislative, and the executive branch. We were told at my school how impressive it was that a poor country like India was able to uphold and maintain the basic principles in the International Convention on Human Rights. The European Convention of Human Rights is relatively young, adopted in 1950 and put into effect in 1953, 5 years after the first resolutions on Kashmir was adopted in the Security Council. This means that we do not have a long history of freedom of expression, freedom of religion, and organizational and political freedom in Europe. For instance, in the Norwegian constitution, it was stated that Jews should have no access to Norway. That was changed, though, around 1850. But it's also stated in the Norwegian constitution that monks and Jesuits should not be tolerated. And that sentence was changed in 1959, almost 10 years after we adopted the European Convention on Human Rights. My point is that we are not in a position to be very proud in Europe of our commitment to human rights and how we have complied with the international convention. It's a constant struggle also for us. But they are the basis for every democracy, the rule of law, social cohesion, and prosperity for the people. Let's take a look at how this is defined in the Indian Constitution. Article 19 of the Constitution from 1949 elaborates the fundamental rights. All citizens shall have the rights. It reads, and the first subclause grants the freedom to speech and expression. In Kashmir, we can now see that this fundamental right to speak and express is increasingly becoming suspended. It's implemented with systematic crackdown and holding individuals from speaking free. I would say one of the things that impressed me positively was when I visited Srinagar 20 years ago. As we were sitting in a meeting with the all-party Hurriyat conference leaders group led by Professor Ali, Professor Ghani Butt, a young boy was shot and killed during that meeting on the vegetable market. Abdul Ghani Butt is his name. It was out of my memory. It was reported by the newspapers the day after that the Indian security forces had shot and killed a boy. And this is how we got to know about it. Of course, the presence of 700,000 military forces made Srinagar into a fortress, which was horrible. But in spite of this, the press was relatively free to report about the atrocities committed by these military forces. But now, today, especially since August 2 years ago, there is no press freedom for Kashmir. The Indian government uses internet blackouts, police raids, and traumatic intimidation tactics on activists, journalists, civilians, to destroy all opposition. And it's very brutal, and also the demographic change they are engineering is in violation of all human rights, international conventions on human rights. At the same time, the regime's followers, they are working overtime to harass people to silence and discredit those who speak out, and those who study and report on Kashmir from abroad as well. So it's a cyber tactic which is being used also towards those abroad who are engaging in the cultural warfare against the Indian authorities. So it's a sad situation. One example is, of course, Mirwais, who was kept in house arrest, and it was even difficult for BBC to have an interview with him. I was happy to stay in contact with him a few times, but I don't think that was legal. So it's a very serious situation now for the journalists and the activists in Kashmir. And it's interesting to see that more and more of even the Indians who had important positions in the administration of India-held Kashmir, Jammu and Kashmir, they are now more and more becoming activists against the Indian government. It's sad to see how democracy falling apart, more and more becoming a dictatorship led by a man who is still a member of a terrorist organization. And we can read his profile through his actions now. And I think we all have to take up the mantle now after Syed Ali Gilani. Each one of us have to work. Of course, we can sit in a seminar like this and say that the international community, they have to fight. And the international press, the diplomats, and the governments of the leading democracies. But I think each one of us has to do something. And think about Gilani as an ideal who died on September the 1st. And we have to start the fight. It's not enough for us to give a speech now and then on a webinar or in a conference. From my point of view, we have to start a massive lobby activity to impact the capitals of the world. Not only Washington, London, Paris, and Berlin, but all capitals are important. All votes counts in the votes in the various United Nations bodies. And of course, I have to speak for myself. Norway carries now a very special responsibility in the months and years to come. We spent millions in a campaign to win a vote to have a seat in the Security Council. And we succeeded with that vote. My question would be, why could we not spend millions in a campaign, in a worldwide campaign, to impact the countries of the world to put pressure on India? Or at least we have to use our seat in the Security Council. We have to ask ourselves now, how can we effectively use that position we have now in the United Nations? From my point of view, this topic that we're discussing today should get on the top of the foreign policy agenda. in every country in the world. It has been more than, or it will soon be 75 years. In a couple of years, it will be 75 years that this war has lasted, the conflict at least. And it is time for a change. Norway needs to play a role, but each of us should play a role to get the topic on the foreign policy agenda. I think that is what it takes to find a solution, how we can put pressure on India and have freedom and the rule of law and human rights for the people of Kashmir. That is my purpose and something I will not give up on. Thank you very much.
Thank you, Lord Rice, for your solidarity with the people of Kashmir and your commitment towards the rights of the people of Kashmir and your personal experience as you have been in Srinagar, met the leaders and also seen by yourself what is happening over there and what's happening now. You have the very good knowledge of that also. And you rightly pointed out that there should be a global moment for this, and each and everyone has to contribute it in. I value your input that Norway should play a role, and of course, Norway has a history of resolving the conflicts around the globe, so Norway should take the lead in this at this point of time, and Kashmir should become a foreign policy agenda in the West, not only in Western capitals, but all over the globe. For that purpose, each and everyone has to do something. We will be very happy to have your advice on this in future, and hopefully when we meet, and we will take this matter to further how to lobby and how to make more inroads in the policy circles in the Europe, in US, and other places. Similarly, Lee also referred to Australia should also speak up. If Australia always speaks for the rights of the Chinese, why not for the people of Kashmir and the Indians? So Europe has to take a lead in now. Though Lars rightly said we don't have a long history of human rights in Europe also, but now since Europe is treated as that they have now assumed a driving seat in promotion and protection of human rights, and European bloc do take on the countries when it comes to human rights, and if it is selective, but we think that they should not be selective in it, as human rights are not selective. They are not that much. It should be for all the peoples, and because these are for the peoples. So the people of Kashmir value your commitment towards the cause of Kashmir, and also Senator Lee's and all the panelists from Advocate Nasir Qadri to Mariana Zaka and Alfar Zayas, who has always been supporting the cause of Kashmir and is trying to bring back this right to self-determination on the agenda of the UN Human Rights Council, which was taken away when the council was formed. So I think we have discussed the criminalization of the freedom of expression. Not only the freedom of expression, opinion is criminalized. Each and every act which is dealing for the rights of the people is being criminalized in India by the current regime. As Lars rightly said, the man who is at the helm of affairs, by his profile, we can see his actions also. Now, what is he doing, and the way the politics is taking place in India. And there are voices in India, there are voices all over the world about his act, the way he conducts the politics in India, and especially in Jammu and Kashmir. We are concerned about the demographic changes which are taking place in Kashmir. And one of the important points which I want to mention is that the curbs on social media, the social media organizations like Facebook, Twitter, Instagram, and others, they are deleting the contents of relating to the Kashmir because, as I earlier said, that India has used a huge IT army in order to report the content which Kashmiris do post on the social media, because the print media and electronic media in Kashmir is totally under suppression. There was only the social media. Now the Kashmiri employees, the people, the government employees in Indian occupied Jammu and Kashmir are under surveillance. Their social media is being scanned by the government of India, and till date, where 22 of the employees were thrown out of the job, and thousands are waiting the screening at this point of time, and we don't know how many more will go. So it's time to act for all of us. What can we do individually, but collectively we can do more, and we should forge unity and a group in order to create a larger awareness on the Kashmir cause, and also make inroads in the policy circles at the global level. I thank you all. If anybody has to say some last word, floor is open. So I think with this, I conclude this webinar. I thank you all for your valuable inputs. Thank you very much.
Thank you. Thank you very much.
Thank you,
It's been a
Marina.
pleasure as always.
Thank you. Thank you so
Thanks
much.
very much.